about National Financial Reporting Authority, or the NAFRA, which is now sort of decided to take over the certain disciplinary proceedings of the ICAI and not the ICAI itself. There's a lot to learn from this act, and as I said before, every problem is an opportunity. And let's look forward to understanding the opportunity from CA Bhavani's presentation. And it's over to Bhavani. Thank you very much.
Good morning, everybody. I thank Sridhanya Corporate Care, Mr. Gopalakrishna Raju, Sri Priya, Mr. Dhanapal, and Smita for inviting me here to be a speaker before you on one of the critical topics which cuts into the basic existence and practice of the audit profession. I was thinking why it was me and Sri Priya here on this topic. And besides what all Sri Priya said, and what I'd like to add is that if it was an invitation from Gopalakrishna Raju and Sri Priya is there, I am there no matter in whatever role. Okay. I still wondered why both of us. And I thought this profession and the role of an auditor today has so much of risk, and that's why the risk experts on statutory audit and internal audit are participating in this session, which is so much exposed to risks today. And that's why an added importance for the combination of Bhavani and Sri Priya. While she has set the tone, picking on the critical aspects of the Act, my presentation today is confined to just the auditor's angle, because various aspects of those provisions which cut across the auditor's existence have been covered in various other sessions or will be covered in other sessions. So this session is like, I found it very difficult to prune down what was covered by others to restrict my session only to purely an auditor's angle. So participants, I believe, would have had coverage of the linked provisions in the other speakers' presentations, and I didn't want to be responsible for boring you with the same aspects. Very simple agenda, just 2 chapters with the rules and only probably 1 section which relates to the role of the auditors. So we would cover appointment and rotation first, then just touch upon the services, powers and duties, the reporting requirements, liabilities, talk about the other audits, and then conclude. Appointment. If we look at appointment, who is eligible for being appointed as an auditor? Fairly straightforward. An individual or a firm, as Sri Priya said, LLPs can be appointed, and only those chartered accountants can sign the financial statements. Majority partner should be practicing CAs. Joint audit scenario is permitted. The audit committee is to consider, before appointing the person, the qualifications and their experience. They should also take into account, what is important to note is the completed and pending proceedings between the auditor placed before the ICAI, NAFRA, tribunal or any court of law. The certificate from an auditor is required for making sure that he or she is eligible for appointment within the proposed term and limits laid down in the Act. My question, as this seminar focuses on the implementation of this Act, my question on implementation: how are pending proceedings under income tax, service tax or any other law for a professional relevant? Why the rules say pending proceedings under any other courts of law? Point to ponder upon. There is a scale down of limits because, as Priya said, that this Act has a preconceived notion that auditors have not been doing their jobs properly. Even aberrations have been thought of as something which applies across the profession. So therefore, they have decided to cut down the limits to number of audits at 20 per partner. What's important to note here is there is no transition provision. And it says that they are disqualified and they vacate office even after being appointed if they don't meet these conditions. So what happens if this section gets notified? Are you vacating office immediately because there is no transition which is applied? So therefore, what happens to these audits? While there is a transition given for 3 years for this case, the changes in limits, they haven't thought about the transition provision. Probably when they give out the final rules, some thought may have been applied. Chambers have, the professionals have represented through the chambers and sent in direct representations for this transition as well. Provisions for appointment and rotation. Fairly straightforward. The first auditor has to be appointed by the board within 30 days. If they are not appointed, then the members can appoint them within 90 days. The tenure of the first auditor would be up to the conclusion of the AGM. Goes without saying that incoming audit firms should not have common partners, and the audit committee is to recommend the auditor. What are those factors on which the audit committee should recommend? It's left to the judgment and the guidance of the board, which would apply its own parameters to select and appoint the auditor. The auditor of a government company also is laid out very clearly: appointment by CAG within 180 days. The first appointment by the CAG within 60 days, if not by the board within 30 days, otherwise by the members in 60 days, and casual vacancy to be filled up by the CAG within 30 days. If it's not filled up, then the board would again take another 30 days to fill up the auditor's position. What happens in the case of reappointment? A retiring auditor is to be reappointed if he is not disqualified and there is no notice of unwillingness in writing, or a special resolution has not been passed by somebody else. And a retiring auditor could be denied reappointment if any of these circumstances exist. Then what do? Send a special notice, the copy to be sent to the retiring auditor, and he has a right of being heard, a representation to be circulated, copy to be filed with the registrar. This is not applicable if the tribunal is satisfied about any abuse by the auditor. Also, there are clear provisions on removal and resignation, removal by a special resolution, by obtaining prior approval of the central government and the auditor is given reasonable opportunity of being heard. There is a form under 10.1 which needs to be filled up and filed. Resignation also has got some processes. The auditor shall within 30 days of resignation file a statement to the company and the registrar indicating the reasons for resignation, and the penalty is quite stringent if there is a failure on this. He can also send a representation in writing, and the notice sent to the shareholders can state that a representation has been received. A copy can be circulated to all the members, and the appointment happens in place of the retiring auditor, of course, with a special notice. Question on implementation. How far will people be transparent giving the reasons for resignation? When an application is made to the central government, normally the grounds of why there is this removal, whether the report has been a qualified report, what is the percentage of capital which is held by those members who are demanding removal, is there a pendency of any audit for the prior years, also has to be clearly stated in the form which makes the application. And there's one more clause which raises the eyebrows of everybody. Are there any books of account in possession of the auditor which is not given back to the company? While the Companies Act has taken into account a lot of proactive steps, has done so much of globalization into the content of drafting, looking at various penalty provisions across the globe. Why are we going back to Stone Age to think about the fact that the auditor would physically possess the books of a company? I think we have all moved out at least 2 decades ago from even ticking the books of a company, leave alone holding the books of account. We are talking about independence. We are talking about electronic age wherein you do remote access and do audits and only physically verify a few assets. And I don't think we could even think of somebody holding possession of the books. I can at least understand if you are doing some IT representation, not for audit purposes. So why this form is still relating to one of the very earlier provisions is something which needs to be looked into. Change of auditor by the tribunal. Changes can be made by the tribunal or by the central government if the auditor has directly or indirectly acted in a fraudulent manner, abetted, colluded in any fraud, okay, with the company, directors, officers. The order by the tribunal stops the auditor from functioning as an auditor within 15 days. Such auditor cannot be appointed for 5 years and he is liable under section 447. As Priya said, 447 is a very, very critical section and we look at it in little more detail as far as the auditors go a little later. The question which I would raise is, once the tribunal is formed, we believe all pending proceedings would get transferred to the tribunal for action. And how will these things be considered? Pending litigations relating to scams, SFIO, mining license or so on. What would happen to them? What would happen to the past cases which have not been judged so far? What would happen to those disciplinary cases of ICAI which have been referred to Supreme Court? And what about those cases which are pending in the lower courts? Will 447 be applied to all these matters or will it start only from those fresh cases after this act is notified? Is a question, because is it the date of the judgment, date of transfer or date of happening of events? I think we need a better clarity to put the profession at rest on this matter. Tenure of the auditor. 5 years, subject to ratification every year, which means conclusion from the first AGM up to the 6th AGM, the auditor can be appointed. It's a compulsory rotation for all companies other than one-person companies and small companies. An individual can be appointed for 5 years and a firm for 10 years. Joint auditors, once they are appointed, it has to be ensured that both of them don't rotate out in the same year. A cooling off of 5 years is stipulated. You could have retrospective and retroactive applicability because the rules do give room for that the past tenure will be considered. The network of firms is to be considered as one and the transition period to apply this provision is 3 years. So what are the effects of these provisions? That's what would happen amongst the auditors. To rotate, musical chair would get played. As it is, everybody is talking about rotation and asking for the first choice or second choice. When anybody meets anybody from the corporate sector, the first thing which comes to their mind is rotation, and I think that has saturated the market space. This topic has saturated the market space. Now, you know, some of the corporates, we've heard comments that we've become like sales personnel, where doctors and others don't want to see the sales representatives anymore. To that extent, this rotation has driven the whole profession, you know, to a very high speed on thinking what would happen tomorrow. So let's look at what happens if this is implemented. The question is manifold. What would happen? Are they really required for private companies? Does rotation really result in independence? Is there much choice in the auditors? Will this lead to cartelization? Will it land in a situation wherein small, medium firms have to invest heavily in technology and training? How many same size companies in the same industry are there? to rotate. Smaller firms could face the hardship to attract new talent. Will this churn cause hardship in initial years? Will there be an unintended harm to quality? And risks could be increased and time and costs for audit would go up. These are some of the thoughts which have been voiced by many professionals, and these questions are very relevant